Good afternoon, everyone, and welcome to our second Stop the Hate event, discussing the future of the LAD and civil rights. Before we get started, I'd like to run over a few housekeeping items so you all know how to participate in today's event. First off, all lines are on mute. If you're interested in receiving CLE credits, please be sure to reply to the poll questions that will pop up sporadically during the program. If you have a question on the discussion, you will have the opportunity to text them into today's presenters. Please type your thoughts into the questions pane of the control panel. You may send them in at any time during the presentation. We will collect these and address them throughout. Similar questions will be combined, and inappropriate or offensive questions will not be announced. And due to time constraints, please keep all questions on topic. If you experience any technical difficulties at any point during our presentation, please explain your problem through the chat feature, and we will try our best to address the issue. Lastly, we are recording this discussion, and the video will be available on our YouTube page within 24 hours. Please subscribe to New Jersey OAG and Civil Rights NJ on YouTube, Twitter, Facebook, Instagram, and Flickr for the latest information on news, resources, and information from our office. Now, I'd like to hand things off to our host and moderator, Rosemary DiSavino, Deputy Director of the New Jersey Division on Civil Rights. Rosemary?
Thank you, Whitney. Good afternoon, everyone. Welcome to the New Jersey Division on Civil Rights celebration of the 75th anniversary of the law against discrimination. Thank you very much for joining us today, and thanks especially to this panel of distinguished lawyers, civil rights advocates, and activists on today's panel. It is truly an honor to share this virtual stage with this distinguished panel, and I'm delighted to welcome Mary Saccone, the Director of Policy and for Disability Rights New Jersey. Welcome, Mary. Sarah Colonnade, the Director and Co-founder of Make the Road New Jersey. Welcome, Sarah. Ryan Haygood, the President and CEO of the New Jersey Institute for Social Justice. Welcome, Ryan. Jean LaCicero, the Legal Director of the ACLU of New Jersey. Welcome, Jean. And last but not least, Akil Roper, Vice President and Assistant General Counsel of Legal Services of New Jersey. Thank you all for joining us today in this roundtable discussion of the law against discrimination, the history of the law against discrimination, and the future of the LAD and civil rights law in the state of New Jersey. I just want to talk about the history, just to give us some context for our discussion. The history of the LAD, as Director Weiner Apter noted in her opening remarks, the LAD is the oldest state civil rights law in the country. It is also one of the broadest laws that offers the promise that our places of work, our places of public accommodation, such as schools, camps, retail establishments like restaurants and stores, and places of housing will be offered to all without regard to membership in a protected class. And of course, protected class includes categories like race, religion, sex, disability, sexual orientation, gender identity, gender expression, and age. The law also, in the employment context, covers all aspects of the employment relationship. So from recruiting, hiring, promotion, wages, benefits, and what the law calls the terms and conditions of employment, which also includes the environment that people are subjected to when they're at work. The law also has a strong prohibition against retaliation that protects the rights of those who stand up to discrimination and report it, complain about it, object to discriminatory policies and practices, and refuse to participate in what they believe is discriminatory acts and practices. So if we look at the law over the last 75 years, it's really quite fascinating. And we invite you all to look at the timeline of the amendments to the LAD that's posted on our website. And I know kind of with interest that the predecessor to the LAD was passed in 1884, and it was a New Jersey law that prohibited discrimination on the basis of race or color or previous condition of servitude in places of public accommodation. So the law is the first to go into effect in the country in 1945, and I don't want to go through every amendment, and there were quite a few, but I do want to point out a few highlights. One is in 1962, the law was amended to add age as a protected class. In 1970, sex and marital status were added as protected classes. 1972, disability was added. In 1977, nationality was added national origin has already been part of the law. In 1992, the New Jersey law against discrimination became one of only a handful of states in the country that had added sexual orientation as a protected class. There were some city ordinances in existence at that time, but very few states had sexual orientation protected. Another groundbreaking amendment was in 2002, when the LAD was amended to prohibit discrimination in housing based on source of lawful income. So that amendment protects people who have Section 8 housing vouchers that they use to rent apartments. In 2006, the law was amended to include gender identity or gender expression. In 2014, the legislature amended the law by passing the Pregnant Workers Fairness Act that explicitly prohibits discrimination against women who are pregnant, who are breastfeeding, or who are affected by pregnancy-related medical conditions. In 2018, the law was amended to make it one of the broadest and strongest equal pay laws in the country, with passage of the Diane B. Equal Pay Act that requires equal pay for all protected categories for substantially similar work. One thing that you realize when you look at the history of the LAD and the amendments is sort of the progression and how the law meets what may be viewed as the need. So in 1970, the law is amended to prohibit discrimination on the basis of sex. And then 48 years later, the law is amended to ensure that women and other protected classes receive equal pay for equal work. Same is true with the Pregnant Workers Fairness Act that was passed in 2014. That amendment is very significant because the language of the statute now requires that women who are pregnant, breastfeeding, or affected by pregnancy are given reasonable accommodations that can include, and again, the statute specifies reasonable accommodations can include bathroom breaks, breaks for increased water intake, periodic rest breaks, help with manual labor, job restructuring, modified work schedules, or a temporary transfer to a less strenuous job. In addition, that amendment also requires that an employer cannot have different policies for pregnant and non-pregnant people. And instead, women affected by pregnancy cannot be treated less favorably by an employer than it treats similarly situated people who are not affected by pregnancy, but are similar in their ability or inability to work. And you'll hear more about that from Jean LaCicero when she talks about a case that was recently decided by the New Jersey Supreme Court, Delanoy versus Township of Ocean. So when we look at the case law, we see that there's not only a progression in the law because the law is amended, but also an evolution in the way that the cases, the subjects really, that the evidence really that the cases are dealing with. So the early cases from the 60s, 70s, and even from the 1980s often deal with very explicit, very blatant instances of discrimination. And I have to add that a lot of the earlier cases were started in the Division on Civil Rights, were heard at a hearing decided by the division, and then taken on appeal to the Appellate Division and the Supreme Court, who more often than not upheld what the division's findings were. So what we want to talk about today is explore an understanding of the areas and the ways in which discrimination and bias-based harassment continue to harm the people of New Jersey. We also want to get a sense of the work that's being done by our distinguished panelists to combat the persistent discrimination and bias-based harassment in New Jersey, even under the current protections of the LAD, and get a sense of the changes that are needed to ensure that the LAD and its enforcing regulations effectively address the ongoing and evolving obstacles to real equality under the law. So let's just turn first to Mary Saccone of Disability Rights New Jersey. Mary, can you just talk a little bit about the work that you're doing and whether there are individuals or communities that you're seeing in your work that are not, but should be beneficiaries of the protections of the LAD?
Okay, thank you, Rosemary. As I said, I'm Mary Saccone. I'm the Director of Policy with Disability Rights New Jersey. I've been with Disability Rights New Jersey for almost 23 years now. As such, I have handled a lot of different cases involving discrimination against individuals with disabilities. And the law against discrimination is a key law in terms of helping people achieve equal status for people with disabilities in employment, in public accommodations. So it's an important law. As Rosemary pointed out, the law against discrimination was amended in 1972, which was a year before the federal Rehabilitation Act of 1973, and 18 years before the Americans with Disabilities Act was enacted. So New Jersey was a leader in terms of providing protections for people with disabilities. That's great. But when you look at what I've been doing, trying to help people try to maintain jobs and get employment, the statistics don't lie. People with disabilities routinely have a higher unemployment rate than people without disabilities. People with disabilities have a higher percentage of people work in part-time than people without disabilities. And people with disabilities are less likely to obtain a bachelor's degree or higher education than people without disabilities. As a result, people with disabilities live in poverty. There's 25.9% of people with disabilities live in poverty versus people without disabilities, which is about 11.4%. So there's still a lot of work to do to try to get people with disabilities opportunities that people without disabilities have. We're talking about what we need to do going forward. One of the big things we try to do at our agency is when people call us, one of the key protections for people with disabilities is if they get a job, they get accommodations so they can maintain their job, reasonable accommodations. And that can be a lot of different things. It can be modifications to their workspace. If you have a wheelchair, you come in, you need a higher desk. They can put in a higher desk. You may need, if you have a visual impairment, maybe you need software that allows you to have your a screen reader to help you read what what's on the screen. So there's all kinds of different technologies. There's issues with respect to job sharing, time away, starting work at different time, modifying your hours. Those types of things are all reasonable accommodations. Things like tests. If a person has to take a test to move up or to get promoted, maybe they need an accommodation in their testing. So there's all kinds of ways. And the law is great in terms of proving that they have to enter into a reason. I'm sorry, I'm talking too fast. My brain is thinking too fast. What I'm trying to say is you have to engage in an interactive process. If a person asks for an accommodation, the employer must engage in an interactive process to find out what is the appropriate accommodation for the person. You may not get the best accommodation, but you get an appropriate one to help them do the fundamental essential functions of their job. So what does that mean? That means that it helps a person maintain employment. And if the employer doesn't do that, then that's discrimination just right off the bat. And it's actually fairly easy to prove, unlike discrimination in terms of hiring and firing, which is very difficult. But the one problem with accommodations is for people who have obvious disabilities, it's very obvious what accommodations they may need. If you have a wheelchair, yes, you do need accommodations, maybe to make sure there's no steps or they can have workspace, that type of thing. And it's very obvious they have a disability. But for a lot of people, they have disabilities that are hidden, most commonly mental illness. And people with mental illness are very reluctant to share their mental health diagnosis because they're afraid that if they do, they're going to get fired. So they may need the accommodation, but they're very reluctant to share their diagnosis. Another thing is they're very scared that they're going to have to provide all their medical documentation to support their request for the accommodation. So for people with hidden disabilities, it is a very challenging circumstance to try to get those accommodations because they have to give some information. They don't have to give all, but they may not want to disclose that they have that disability. And it can be a real problem for them. Going forward, we're going to see a lot more people with disabilities that never had them. COVID has left people with long-term COVID, which they've had, lung issues, breathing issues, some neurological symptoms. There's a lot of issues that are going to go forward. There's also the issue of people who have some type of high-risk disease. Maybe they have diabetes and they don't want to go back into the workplace. Are they going to be able to continue to work from home when the employer says, let's go back? And they say, well, no, I'm at high risk. If I get COVID, I'm going to die. So there's a lot of things that are going to be going forward. And I think people haven't really thought in terms of how is that going to play out. And I think the law against discrimination is going to be a key factor in terms of trying to work through those and provide protections to people with disabilities as they have to return to work. So that's kind of what I want to say. I'll let, if you have any questions, let me know. Rosemary, I think you're on mute.
Of course. Thank you very much. That's a lot of useful information that you just gave us. I just wonder what sort of advice do you give to people who have what you've referred to as a hidden disability, who require an accommodation but are scared to disclose their disability to their employer?
It's a really tough circumstance. People with mental illness, one of the biggest issues for them is they may take medications that are the timing of them, they cannot get up early in the morning. And as a result, they are, because they may have to be at work at 8 o'clock, but they can't get themselves up and moving because of their medication till 10 o'clock. So they really do need an accommodation in their times. But how do they do that? Because in order to get the accommodation, they have to disclose that they have the disability. They can't just say, I have a disability and I want to work from 10 to 6 versus 8 to 4. But if they don't tell it, then they're likely to lose their job because they're late to work every day. So it is, when we work with people, we try to reassure them that, one, the law protects them, but, and the employer must keep their medical information confidential. They can't be going and telling everybody in the world that they have this disability. But it is really hard for them to say, I want to disclose. So it's a real balancing, and it's got to be something that eventually the person has to make the decision. But it's, we do a lot of counseling on that issue, and it is it's not something that I can really understand unless a person really understands, unless they have that disability. But the way the law is written, you have to disclose your disability. You have to provide some documentation to say you have this disability.
Yep. And you have to hope that people are going to abide by the law and keep medical information private and not share information with other people who would then, perhaps act on biases or prejudices based on something that somebody else tells them. So it's a difficult situation. Thank you, Mary. Sarah, I wonder if you are seeing any individuals or communities in your work, or you could talk a little bit about your work and let us know if you're seeing any individuals or communities, groups of individuals that aren't getting the full benefit of the law against discrimination currently, or what kind of problems you're seeing.
Thank you so much, Rosemary. It's great to be here with you all and with a really incredible panel of advocates who I've learned a lot from over the years, and I'm grateful to have this discussion. So my name's Sarah Cullinane. I'm the director of Make the Road New Jersey. We're a grassroots immigrant and workers' rights organization. We focus on community organizing. Our members lead campaigns to expand their rights and to protect their dignity. And we also offer legal services. We have 7 attorneys on staff who represent people in immigration and workplace and other matters. And, in my background, I actually started, before I started Make the Road New Jersey with the organization 6 years ago, I was an attorney representing individuals, immigrant workers in workplace issues in New York. And I remember coming to New Jersey and my colleagues in New York saying, the NJLAT is an incredible tool to use. It is expansive. It is a great tool, and sort of, sharing that would be an exciting, and in addition to other workplace protections, an exciting sort of way to support low-wage workers, immigrant workers. So, in my experience, I've approached the LAD mostly from an employment context, and, wanted to sort of share some of our experiences. While certainly immigrant communities, immigrant individuals are protected under the LAD in many situations. I'll focus most of my comments on workplace issues. And so, I think, while the LAD can be incredibly helpful to immigrants, there's also several ways where it's very limited. And so I wanted to sort of share some of the ways that the LAD has been incredibly helpful, some of the issues faced by immigrant communities, and then some suggestions on how we could reform some of the limitations. So of course, immigrant workers are an incredibly important part of the workforce. There are about 500,000 undocumented immigrant individuals living in New Jersey, and the majority of them are workers in the workplace, in low-wage work and frontline work. 209,000 could be considered essential workers now. And we know that immigrant workers face really severe and pernicious discrimination, often based on the fact that they're working in very precarious working conditions. Many of our members work, for example, as temp workers, permatemps. They've been working for 10 years sometimes for a temp agency that puts them in different warehouses and different employers across the state, sometimes in the same employer for many years, but they're still considered temp workers. They rely often on their employers to provide transportation to get to work because they're unable to drive. And oftentimes employers attempt to pay the workers sub-minimum wages. And so within this sort of precarious working condition, discrimination, harassment, even assault can be pretty commonplace. It's not uncommon for our members to talk about experiencing sexual harassment in the workplace, experiencing insults, threats that their employer will call ICE if they speak up, retaliation for speaking up. And this happens in large workplaces like big warehouses. New Labor did a really important report about documenting sexual harassment in temp agencies, and in particular for the employers that provide transportation, how the van is a location where there's really often heightened sexual harassment, assault. And then of course, domestic workers. Many of our members are employed as domestic workers. And there, again, there's a really intense power imbalance, and we've seen discrimination, attacks, assaults on workers in a pretty devastating way. And so, the LAD is a really important tool, and it is not the only tool that that is used by immigrant workers to protect themselves. So one way, just to sort of share what the ways that the LAD is really important, it's first and foremost, it covers all workers, regardless of immigration status, and that is critical. You do not have to have lawful immigration status to be protected by the law against discrimination in New Jersey. The second is, just the very expansive definitions and protective classes are, mean that immigrant workers, low-wage workers can be potentially classified under several protective classes and use the law to protect themselves in that way. And the strong anti-retaliation provisions, those have been essential to protect individuals once they come forward. And I'd also add, I know that there's work being done to expand the definition and expand the coverage, but there is a very strong test for who's a worker, and that can include some people who have been misclassified or classified as independent contractors, which is a common situation among immigrant workers. So I think while these are really important protections, we do see several ways, in particular, that immigrant workers, undocumented workers, and domestic workers are left behind. So the first is in the question of winning relief, especially in the workplace for undocumented workers. So there was an unfortunate case, Crespo v. Evergo Corp., where the plaintiff was an undocumented worker, and her claim was that her employer refused to permit her to return to work after she went on maternity leave. And the appellate division had held in that case that an undocumented worker who gained employment that was not lawfully eligible to work was disqualified from receiving or ineligible to receive any recovery of back wages or front wages or reinstatement, because when she first applied to work, she was ineligible due to her immigration status. She didn't have lawful immigration status or work authorization. And so I think, that that decision was troubling, and it's, in the context of broader, case law and that has also limited back pay, front pay, and reinstatement for immigrant workers, throughout the courts. But it doesn't mean, but the sort of case itself doesn't bar immigrant workers from receiving any type of relief of compensation. And so, there's arguments to be made, and I know lawyers have been creative and being able to win economic relief, for example, for tangible physical or emotional harm. And there have also been ways to negotiate reinstatement as part of a settlement. But I think, thinking about a fix to Crespo, and there's also broader, concerns from Supreme Court precedent on similar issues as well, is an important way to think about how we have to change the LAD. And the second is, the LAD prohibits discrimination based on national origin and nationality, but it doesn't actually prohibit discrimination based on immigration status or citizenship status. And some municipalities have made those changes to their local laws, local anti-discrimination laws, and that would be a welcome step for New Jersey to, and I think there's been discussion of potential amendments to include as a protected class immigration status or citizenship status. And we've seen that especially under the Trump administration, where people were threatened in housing situation and workplace situation with deportation if they stood up to try to protect themselves. And having immigration status as a protected class itself could help cover more people and provide additional protection. And I'll also just add, and I know this is a proposed amendment already, but absolutely including domestic workers under the law against discrimination is incredibly important. We're happy to see that has been moving forward. And then, I just briefly wanted to touch on a separate issue, but has also started, we're seeing it crop up more and more and more among our membership, which is, being litigated as we speak with the question of forced arbitration. So the LAD has been very explicit. Section 12.7 prohibits the prospective waiver of any right and provides that employment contracts containing a provision that waives any right related to employees' claim of retaliation, discrimination, or harassment is against public policy and enforceable. So we have seen that employers are increasingly including forced arbitration clauses, and oftentimes people think of this as something that only impacts white collar workers, but we're seeing an increased amount of low wage immigrant workers having to sign on to forced arbitration clauses. And so I think the fact that the LAD really takes a stand against forced arbitration is critically important. We know that there's been some bad decisions in the court recently, and the issues being litigated as we speak, been challenged by the Chamber of Commerce and others. But when individuals lose their right to a trial, to going to being heard before the courts, it has a really drastic impact on individuals' ability to really have their case heard. And so I would just flag that as another area of the LAD that's important to protect and lift up. And yeah, thank you so much.
Yeah, thank you very much, Sarah. It's when we had in 2019, the Division on Civil Rights conducted sexual harassment hearings around the state. We had some of the most compelling testimony from domestic workers and undocumented people. And these are folks who are, as you say, on the front lines, essential workers who have no protection under the current law and are among really some of our most vulnerable workers, and face a situation that a lot of other people don't even have to think about, because if you're undocumented, right, how vulnerable are you to an abusive workplace or a discriminatory workplace? Because if you say anything, you face deportation. And that is sort of an incentive for some people and some employers to actually take advantage of even more vulnerable workers. Thank you, Sarah. Nobody else has any other comments at the moment. We will turn to Ryan Haygood. Ryan, do you want to talk about some individuals or communities that you're seeing in your work who should be but are not afforded protections under the LAD?
Sure. Thanks, Rosemary. Thanks for the chance to be here with friends, with Jean and Sarah, Akil and Mary. I've been thinking a lot about this particular moment as one that's both very painful for all the reasons we've been experiencing in the throes of the coronavirus pandemic, in the throes of a broader police brutality pandemic, in the throes of a structural racism pandemic. But I've also been thinking to the point that Rosemary made in her opening remarks about how I think in some of our most painful moments, they're the most precious opportunities to advance the kind of work that we all do collectively and the work that we do here at the Institute for Social Justice around racial justice. So as was mentioned, my name is Ryan Haygood, and I have the pleasure of working at the New Jersey Institute for Social Justice. We're a legal advocacy organization whose mission really is to identify and then work to topple sort of structural load-bearing walls of racial inequality. And our work is organized in three interconnected pillars around economic justice, criminal justice reform, and democracy and justice. And so I really just wanted to say a word about the LAD and sort of what animated the creation of it 75 years ago. I spent some time looking at the legislative history, and some of it says that the legislature finds that because of discrimination, people suffer personal hardships and the state suffers a grievous harm. And I was struck by the recognition that discrimination in all the forms we find it, that folks have spoken to here and will speak to more, that discrimination is harmful to people individually, but it also says that the state of New Jersey, the Garden State, suffers a grievous harm, that racial discrimination, other discrimination is harmful to individuals and to the broader state. And I just want to say a word about how I think that shows up 75 years after the LAD was passed. So Whitney is gracious enough to advance a couple of slides I have here, the first of which will appear here. Thanks, Whitney. And so to capture this idea, this is an image my colleague Jake put together here at the Institute. You can see it's an image of a young Black boy, and he's standing on a foundation, and the foundation is cracked. And we think a lot about how the foundation is cracked by structural racism. And particularly in this moment, in the COVID-19 pandemic moment, communities of color, Black, brown, other communities of color are experiencing real earthquakes through those cracks in our communities. And so the work that we seek to do in partnership with folks on the line and many of you watching and the state of New Jersey is to think about how do we build systems to fill in those cracks, right? Those cracks, to be clear, are by design. The LAD recognizes that. In fact, what sort of the vision for the LAD was to build a New Jersey that is free from discrimination in all of its manifestations. And so a lot of our work around policy reform is how do we build systems, recognizing those cracks are there, recognizing that we inherited those cracks, right? Those cracks go back to the foundation of New Jersey as a colony, that we inherit those cracks, but we take responsibility for filling in those cracks to build a new foundation. Next slide, please, Whitney. And so I just wanted to share, particularly given this moment that we're in, a really striking image of George Floyd. This is the cover of the New Yorker magazine from June of 2020. It is striking for all the reasons that occurred to you, particularly if you've not seen it before. What captures me is that if you look at the center of Mr. Floyd's outline, you'll see there's a white car with some folks around a person on the ground, and that person on the ground is Rodney King. And this was March 3rd, 1991, when I was in high school. And what was important about that moment was a moment where the brutality of Rodney King by 4 Los Angeles police officers was captured on videotape, right? And 30 years later, we're talking about the continued brutality of Black people in particular at the hands of law enforcement. Here's George Floyd. Before we joined the call, I was following the Dante Wright development, and also in Minnesota, not far from where the trial of the officer who killed George Floyd is taking place. And I think this speaks to the cracks in our foundation nationally, but they also show up here in New Jersey. And this is illustrated by the next slide. Thanks, Whitney. So there's a quote that Dr. King offered us some time ago where he said, you don't have to see the whole staircase, just take the first step. But in the next slide, thanks, Whitney, you see the whole staircase. And this is a staircase that captures the work that we do around racial disparities. We spend a lot of time here at the Institute understanding what the racial disparities are in New Jersey, and then helping to understand what these racial disparities reflect, which is structural racism. They're not reflections of individual failures. And then as importantly, then how do we build systems through policies, through practices, through regulations, through laws to help interrupt the racial disparities. And so this is really a striking image. I'll only offer up a couple, but it's important to note that for all of the incredible prosperity in New Jersey, right? We're one of the wealthiest states in the country, second only to Maryland. For all of the incredible racial diversity, we're one of the most racially diverse states in the country. We're also a state where that incredible wealth exists alongside some really punishing poverty, where that rich racial diversity exists alongside some really entrenched racial segregation. And so I just want to offer up a couple here. Again, you'll see the same Black boy who was standing on the cracks a few slides earlier, looking up at how those cracks manifest themselves in racial disparities. And it's important to know that in New Jersey, Black folks face some of the worst racial disparities in the country, 75 years after the LAD was penned, right? In the front, you'll see the first racial disparity, 352 is the number. You see $352,000. That is a reflection of the median net wealth of white families in New Jersey. The average white family in New Jersey has a median net wealth of $352,000. But if you look to the right, you see that there's a $6,100 figure and a $7,300 figure. The $6,100 figure is the median net wealth for Black families. The $7,300 figure is the median net wealth for Latino families. And if you go up one more step, my colleague Laura Sullivan was able to break these numbers down on an individual level. So she was able to look at the individual net wealth of adults in New Jersey. And there you'll see that the individual net wealth for white adults in New Jersey is $106,000. But the individual net wealth for Black and brown adults in New Jersey is just $179, right? That's less than the cost of a laptop, less than the cost of a computer. And those numbers, those racial disparities in wealth in New Jersey were conceived of, they were created in New Jersey's own relationship with slavery. That New Jersey was a state where slavery took root very, very deeply. It was a colony built on slavery. It was a colony that gave each white settling English family 100 acres, and it gave those families an additional amount of acres for each enslaved person that worked on that land. New Jersey is also a state that had its own form of sharecropping. And you'll see a direct line from slavery to these racial wealth gap disparities that I lifted up. Quickly want to just go up a couple more slides specific to this Black boy. You'll see a number 21-1. And 21-1 reflects the racial disparity in Black to white youth incarceration in New Jersey. And so that number shows that in New Jersey, a Black child, a Black youth, a Black young person is 21 times more likely to be in prison than a white youth, even though we know that Black and white kids commit most offenses at about the same rate. That number reflects very different policy decisions that attach when white kids commit criminal offenses than when Black kids do. And we know this because in New Jersey, a state of 9 million people, there are 8 white kids in prison in the whole state, and the rest are Black and brown. And last thing I'll say here on this racial disparity is that New Jersey has been a national leader in reducing its overall prison population in the adult and the youth justice system. That's something that we stand out as and can be proud of, to be sure. But even as we've reduced our prison populations, the racial disparities have exploded. And in the youth justice context in particular, even though our youth prisons are overwhelmingly empty, we continue to staff them with adults as if they're completely full. So New Jersey today has 119 young people in its 3 youth prisons. Total youth incarceration population, 119 young people. But we staff those prisons as if they're at capacity, which is 514 young people. And so because the youth prisons are mostly empty, but are staffed with adults as if at capacity, this year, New Jersey is investing $445,000 to incarcerate each young person. And that staggering reality, that investment in incarceration of young people, in particular, young Black and brown people, to be specific, led me to this next slide. I've only got a couple here to go. And I tell this story as often as I can. It involves my wife, who's the principal of a K-8 district school here in Newark. This is her with the A on her shirt with a computer in her hand and her fist raised. And the A is for Avon Avenue, which is where she's been the principal for 11 years now. And this is her team around her. This photo was taken back in April of 2020. It was at the beginning of the pandemic, and the superintendent encouraged all of the administrators to get every one of their scholars a computer from the school. That was the mandate, so the kids could learn at home online. And so her name is Charity, and her team quickly distributed all the computers they had. They delivered them to homes. They delivered enough to get 1 computer to each family, but they didn't have enough for each kid in each family, because for those scholars for those families where there's more than 1 scholar, those families only had 1 computer. And so a gentleman named Michael Rowe, who hosts a national show called Returning the Favor, learned about how Charity and her team were distributing computers to their scholars, and he gifted Charity School $25,000. It was enough to purchase those computers you see on the left, and she and her team distributed 125 computers to her scholars, so that there was a 1-to-1 scholar to computer ratio. Every kid at Avon Avenue School, thanks to that generosity, now had a means to learn at home. Next slide, Whitney, or so we thought. Because we quickly learned that with these 2 of Charity scholars here, that a good number of the young people, though they now had in their laps the world's most powerful device, they did not have the thing that they needed to access the information on. And what would that be? Of course, right? The internet. And so these 2 students, in fact, if my wife were here to tell the story, she would tell you about how this is a picture of, she doesn't love the word resilience, right? Because that often imposes things on the person to navigate really painful and cold-blooded systems and structures. But she talked about their perseverance, right? That they thought enough to move their computers to their desks or the window sills because a neighbor had Wi-Fi, and the neighbor let them use their Wi-Fi so they could log on to learn. So they created for themselves a desk and seats. And she'd also say, if you look at the kid on the right, he's very focused, got a certain posture. He could do something like be a lawyer, right? Because he's very focused. But the young kid on the right, she would talk about his beautiful form. He might be in the arts world someday, an artist or a dancer, right? But she would say a lot about how this speaks about the perseverance of young people, but it also speaks about failed systems. How every community, like my wife, like her colleagues, like so many of us watching this program, are heroes in our communities, but heroes are not supplements for failed systems. In fact, there's a limitation, as we see from Charity's example. You can get the kids the computer, but if there is not a system that provides internet, they can't access even that act of heroism. Next slide. And so that led me to this, thanks, Whitney, this quote, another from Dr. King, where he talked about in his book, Challenge of a New Age, but the end, he talks about the ends, right? And I think a lot about the LAD was created with a beginning 75 years ago, but it had an end in mind. And I think this is part of what that end contemplated, that the end is reconciliation, that the end is redemption, that the end is the creation of the beloved community, that the LAD provided a forward-thinking, transformative framework to stop and repair the harm of discrimination. But it needs complements to realize what animated it. And the last slide here, please, Whitney, is just a bit about how we've been approaching it at the Institute. So we've been thinking then, how do you do things like build wealth? How do you build systems that connect communities separated from wealth to the prosperity, the incredible prosperity in our state? How do you transform justice? You know, how does New Jersey take those 119 kids, close those youth prisons, put those kids not in prisons, but in facilities that will help to rehabilitate them? How does New Jersey take that $445,000 investment in incarcerating kids and build up those kids, like those two who were learning at home in that home office that they made out of what they could find? How do we build power? Through expanding democracy. New Jersey has been a national leader very recently, last couple of years, working closely with Governor Murphy and his team to do things like last week pass early voting, to restore the right to vote to 83,000 people on probation and parole, to pass online voter registration, and to go further around extending the right to vote to people who are in prison, passing on on same day voter registration, and doing things like ending the line, the way that we conduct elections in very partisan ways. And then finally, and this is mentioned in the LAD, I think of it in a little different context. This is my last point, I promise, Rosemary, on the idea of repairing the harm of racism. Today, there was a hearing in the House on a bill that John Conyers introduced 35 years ago, the late John Conyers, that would create a reparations task force. It would do two things. One, it would look at the role of America in slavery, and two, it would make policy recommendations to repair that enduring harm. And New Jersey should do that as well. There was a bill introduced that would create a New Jersey reparations task force that I think is an important piece of legislation and an important piece of this conversation. You can find this a document we created, Black in New Jersey. It's our 2021-22 agenda to make Black lives really matter in New Jersey. You can find that on our website. And thanks for the chance to be here with you all today.
Rosemary, you're muted.
Sorry, Ryan. Hey, good. Thank you so much. I apologize for the awkwardness, but we have a question that popped up, I guess, for CLEs that's on the screen. So I'll alert you to that. We could talk about systemic racism all day and why and how the LAD has prohibited discrimination on the basis of race since, going back, as I said, to 1884. And here we sit looking at the numbers that you put together for us, Ryan, is pretty profound. And I thank you for that. There was a comment in the chat. I'm sorry.
Rosemary, did you want me to speak it out here?
Okay,
I have it.
Thank you.
No problem. So we have an anonymous question here. I provide legal services to NJ tenants of low income. Can we do anything to stop landlords from refusing to rent to tenants whose sole source of income is on unemployment benefits?
Does anybody want to take that question? I was actually, there was another question for Ryan Whitney about Ryan's mentioned that there were only 8 white youth are in prison.
Yeah, no. So I appreciate that the person caught that. I think the number is staggering. That number comes from the Juvenile Justice Commission itself. So we rely on the JJC for those numbers. And, I think what occurs to me when I see that number, and I'm sure the person who lifted it up is, right, that is not a reflection of the rate at which white kids commit criminal offenses, right? We know that kids We've all been young. At some point we were young, and if we're young now, we were younger. And when we were younger, we did things that we may not have been proud of. Some of those things may have even been illegal, right? But we know that the number of white kids in prison, 8, doesn't reflect actual participation in crime. What it reflects is a very different response to white kids when they do things that may run afoul of the law. Very often, we've seen that one of the policy things that General Graywall was, I think, a national leader in helping to effectuate, along with the ACLU of New Jersey and the Institute, is a more even use of station house adjustments, right? So we saw they were very unevenly used across New Jersey, which is one of the things that drives the low number of white kids in prison. And what we seek to do as part of our work is to marshal the same kind of compassion and response to young white kids when they do things that kids do, to direct that at Black and brown kids, to make different kinds of investments and empower kids, not incarcerate kids.
Great, thank you, Brian. Whitney, would just allow Jean and Akil an opportunity to speak and then go back to the questions. Would that be all right? Or are there other questions we should pose now?
That's all that we've got, so that works well.
Great, okay. Jean LaCicero, Legal Director of the ACLU of New Jersey, can you talk a little bit about the groups that you see, or communities or individuals that should be but are not presently beneficiaries of the protections of the law against discrimination?
Thank you, Rosemary. And I'm so thrilled to be on this panel with all of these amazing advocates in the state. And let me just say, it's hard to follow Ryan Haygood. That was an amazing presentation. And he identified a lot of the systems that we're all struggling against that really impact Black and brown communities throughout the state. And so at the ACLU of New Jersey, we work to protect and expand civil rights, but we really are thinking about how can we make New Jersey a fairer, more equitable place for everyone. And so a lot of that work centers around criminal justice, police practices, ending mass incarceration. It also, we focus on immigrants' rights, and we focus on, we do a lot of anti-discrimination work in the context of that. And we try to use all of the tools at our disposal. A lot of the problems Ryan talked about, are really hard to, get into existing laws. And so we have to be on the policy front lines, really creating new ones and creating new systems and filling in those cracks, like he said. And so, when I think about the law against discrimination, it is a key tool in our toolbox. And just to give you a little bit of background for me, when I started my legal career, I was a law fellow at the ACLU of Alabama in Montgomery. And I did that for a year. And at the time, and still today, there are no state anti-discrimination protections in Alabama. And so we would get all kinds of complaints from people around the state about discrimination they were facing. And they had no mechanism to address that other than going into federal court. And there are some federal protections that are available to folks, especially in the employment context, but with public accommodations and other mechanisms, there's so many barriers. The federal courts are just not ideal places to bring civil rights cases because they're so intensive and resource intensive too. And so, and let me just tell you, at the time when I was there, not a lot of civil rights attorneys in Alabama just doing the work. It's really hard. And so then fast forward a few years later, and I get to come home to my home state and work at the ACLU of New Jersey. And I really got to dig into the law against discrimination, and so have a really deep appreciation for what the LAD is trying to do, and to have BCR available to people so that you don't necessarily have to go to a lawyer, but that the division accepts complaints from people. That's really meaningful in trying to address individual circumstances of discrimination. And just to be clear, harassment and discrimination in all of its forms really undermines our communities, our safety, our dignity, and equality. And I too, like Brian, look back at the law against discrimination and its origins, and the another part of the statute that I looked at, really also gets to the point about this isn't just an individual harm, but the legislature actually said that discrimination menaces the institutions and foundations of a free democratic state. And so that, that New Jersey has such solid public policy against discrimination really provides a lot of opportunities for advocates to use the law against discrimination in the courts, but also in other contexts to move the ball forward for their clients, and so or communities. So just to say that it's a work in progress, the law against discrimination. And Rosemary mentioned at the top a lot of the amendments that happen, and that happens because residents and activists and communities are pushing for more expanded protections, and Sarah named some of the ones we need. And the legislature has responded, although sometimes slowly. So I'll just note that. But there's more work to be done, and so that we see the LAD as a work in progress and as ways for us to provide meaningful anti-discrimination protections for people more expansively, I think is something I really appreciate about being here in New Jersey. And so I know part of what you wanted me to talk about is related to gender and LGBTQ issues. And so I'll talk a little bit about how that has shown up in my work. As Rosemary mentioned, just recently, the New Jersey Supreme Court ruled on a case regarding the Pregnant Workers Fairness Act. And New Jersey, again, leading the pack, the protections for pregnant workers is really one of the strongest in the country. And it's another example of how the LAD needed to be amended, because even though pregnant workers were ostensibly protected by the existing law against discrimination, courts in the context of the federal law and in the context of the LAD were finding that we're interpreting the law to protect pregnant workers so that they weren't being treated worse than other employees. Now, of course, that means that employers could treat their workers equally poorly. So that if you're a cashier and they don't allow any stools for workers, then they didn't have to provide one for pregnant worker. And so that amendment, as Rosemary said, really kind of shifted the dynamic. And not only were employers prohibited from discriminating against pregnant workers, but then also had affirmative obligations to try to really accommodate them and provide meaningful space in the workplace, right? Because 85% of women are going to become pregnant at least once in their lives, and they comprise more than half of the workforce. Our workforces, our workplaces need to accommodate, people who get pregnant. That's just, part of what they need to anticipate. And so the Pregnant Workers Fairness Act really shifts that in favor of workers and protecting them. And so the Supreme Court decision affirmed that, fortunately, and talked about 3 different ways to protect them, 3 different requirements, I guess, which is that employers have to, or you could bring a claim if employers treat you unfavorably or unequally, or if they fail to accommodate you, or if you ask for an accommodation and they give it to you, but then they penalize you in some other way. So it's really broad. And so I'm hoping that with this new Supreme Court decision and some education among employers and workers, that can have real meaningful impacts across the state. And we of course know that usually this is, or disproportionately, the pregnancy discrimination is impacting low-wage workers and women and workers of color. And so so it's especially, an important tool in that context as well. Also wanted to give a shout out to DCR for its work on sexual harassment and the hearings they held, I guess it was 2019. And the report that came out of that, as Sarah and Rosemary both mentioned, there was some really powerful testimony, and so the recommendations that came out of that, I think, are really significant as far as expanding what it means to be an employee, including domestic workers in that, and also other types of temporary or workers like interns who might be subject to sexual or other kinds of harassment and be earlier in their careers, or have like a big power differential and not have a pathway to deal with that. Also in there, which I think is generally a good idea for all of the claims regarding the law against discrimination, is expanding the statute of limitations. We know that harassment and bias can be very traumatizing experiences. And also people are at different points in their lives, have different, different dynamics or family obligations, which make it hard to file a complaint with the division within 180 days, or even bring a lawsuit within 2 years. And so expanding the statute of limitations is another opportunity, I think, to expand the impact of the law against discrimination. I'm going to pivot a little bit to transgender justice and transgender discrimination, because that's been another important part of my practice and work at the ACLU. I got to serve on the the governor's Transgender Equality Task Force, which with a lot of the staff members from the division and across the state to really examine and tackle some of the structural issues and discrimination and bias that transgender people face. And we identified and documented, and I commend you to the report, discrimination based in education and housing and employment. And the LAD can be a tool to resolve all of that. One area that I've been able to focus on in my work is in the context of public accommodations. And I'll say that's partly because of the LAD, there's a very sophisticated group of lawyers across the state who can take employment cases. And then there are other advocates other than the ACLU that really focus on housing discrimination. And so we kind of step into the public accommodation space. And so one way we've been looking at that part of the LAD and in the context of transgender rights is in prisons and jails. And so prisons and jails are public accommodations, and we've sued the Department of Corrections regarding discriminatory and harassing and biased treatment against transgender prisoner. One in particular, our lawsuits are on behalf of one transgender prisoner, but I'll tell you that prisons and jails across the state are very hostile, toxic environments and discriminate on many bases. And so we've seen that at the women's prison in the state, horrific violence and harassment and assault happening. And the LAD has been a tool there. There were headlines last week about a lawsuit being resolved on that. But just to say that, the scale of what went on at the women's prison is alarming, horrifying, alarming, all of those words. But it happens across the state. And so that's another area where I think I would encourage advocates to join the ACLU and others to really examine the kinds of toxic environment, including in immigration detention. And the way Sarah mentioned that, immigration status isn't protected, but we do have other options to look at ethnicity and national origin discrimination. So I think I'll stop there unless folks have questions for me.
Amazing. Thank you, Jean. I just there's so much to say to all of you after your comments, but there isn't enough time. But Jean, your comments reminded me that I neglected to mention on the statute of limitations issue. So the governor has signed an executive order declaring a public health emergency. And there's another executive order that extends the statute of limitations for filing with the Division on Civil Rights during dependency and until I think 30 days after the public health emergency is over. So at this point, our statute of limitations is told. I'm really glad that you mentioned that, so we can try to get the word out to you all and to other people that the statute of limitations is at this point told.
That's great news. Thanks for flagging.
Yes. And there is more information about that on our website. So thank you, everyone. I'm really proud and happy to introduce next Akil Roper, Vice President Assistant General Counsel, Legal Services of New Jersey. Welcome, Akil. And I would ask that you also address whether in your work you are seeing individuals or communities that should be but are not currently beneficiaries of the LAD, and if so, what can we do to address that? Thank you, Akil.
Thank you, Rosemary. Thank you for the invitation to participate in this esteemed panel with the Division on Civil Rights and these renowned advocacy leaders. I have a lot of respect for everybody on this panel and all those who are joining us today. It is a true honor to be able to talk about a little bit about the work that I do. And as the Deputy Director explained, the LAD is the state's civil rights law and one of the nation's strongest and broadest anti-discrimination laws. And it's our position at LSNJ that discrimination in all its forms is a reprehensible practice, and it's crucial that we do all we can to uproot it and do it in an active way. Equal justice and fairness dictate that we have an obligation to protect the civil rights of all people. It's in the nature of discrimination, though, that it falls harshly on certain groups and classifications, and that is why we have protections embedded in our laws, particularly the LAD, and as upheld by our courts. But as Mr. Haygood was referencing, we need actors. We need people to help, partners to help ensure that justice is pursued and ultimately served. At LSNJ and the regional programs, it's a statewide system. And so legal services programs in general arose from the 1960s civil rights movement and were created specifically to ensure that equal access to justice, substantive and procedural justice in civil legal matters for the poor. So being of a certain income level does not create a protected class status, but many of the protected classes are in fact lower income and of course subject to protection under the LAD. There is no civil Gideon, right? So there's no right to representation for people in poverty for their civil legal matters, but that is our role as part of the legal services system and our mission to provide representation and legal assistance to as many as we can, given our available resources. It's a system to protect and enforce people's rights and essentially operates as a public defender for civil legal matters. And as a system, just as an aside, we have a presence in all 21 counties through 5 regional offices: Northeast Legal Services, Northwest New Jersey Legal Services, Essex Newark, Central Jersey Legal Services, and South Jersey Legal Services. And those regional offices are largely focused on the delivery of direct legal services to low-income individuals, principally in core areas such as housing, public entitlements, family, and consumer law. And LSNJ, we coordinate and support that statewide system by providing assistance in matters of broader statewide significance, impact litigation, responding to particular needs of vulnerable populations, spearheading advocacy efforts, and housing special representation projects. We conduct trainings, provide resources for the non-represented individuals to help get access to the courts and get a fairer shake at the courthouse. We maintain a technology infrastructure and operate a statewide hotline, as the harsh reality is that we cannot provide full representation to everyone who walks through our doors. That's one of the ways we've tried to do this, right? Through our pro se materials that are available and our statewide hotline where folks can at least get advice. In addition, our Poverty Research Institute collects and analyzes data on poverty in New Jersey and sheds light on the reality of poverty in the state. And soon to be released poverty reports are going to show that almost 1/3 of the state experiences what we refer to as true poverty. And those are individuals and families facing deprivation of at least one important need as a result of not being able to afford basic necessities. It's a huge problem in the state. I also want to talk a minute to talk about our anti-racist approach. And the reason for this is going to become clear a little bit later, but looking within an organization like ours and others, we're taking anti-racism approach and assessing where we are in terms of bias, education, our understandings of racism, trainings on mechanisms on how to check implicit bias, taking a systems focus and approach in our advocacy, including strategic planning and continued oversight. So even as advocates for the poor and underserved, we have to fully embrace race equity and listen to the community and do all these things and mechanisms to check our implicit bias and in a careful and deliberate way. The connection to the community through regional programs, our outreach, statewide hotline helps drive the advocacy and the systems work which we take on. And so like the Deputy Director and others have aptly noted, discrimination today doesn't exactly look like it looked like in the 60s. but it manifests and rears its ugly head in other ways. In 2008, I began working as an attorney in legal services reentry project and came familiar with a set of problems, particularly facing low-income community and communities of color in New Jersey: criminal record discrimination. So people with records of arrest and conviction are frequently, routinely denied opportunities simply because of a record that shows up during the application process, reflective of something that happened in that individual's past. Now, sometimes this is referred to as collateral consequences, but what it really is discrimination. And so making an adverse decision about someone without any consideration of how that conduct affects or is related to the job performance or safety is discrimination. And so restrictive criminal record policies are simply unjust, and it's a widespread problem. Research tells us that 1 in 3 people have something that'll show up on a background report. But there's a few different things going on here, and Mr. Hager touched on this a bit. So there are laws on the books, right, which specifically state that people with criminal records are ineligible for certain employment, certain housing. But you also have this bias, which fuels this fear and this distrust of Black people and Black men, particularly with justice involvement. There was a study by Deva Pager that whites with criminal records fared much better in the job market than Black people with criminal records. So again, that's why that implicit bias and the checking bias piece comes back in again, because that's important to unpack that discrimination that's happening on an individual level for folks who are going and moving through these systems. So in terms of prisoner reentry, fundamentally, we should be trying to make it easier for people in the reentry community to get jobs and get housing, not the other way around, right? We need employment now, we need housing now. Why pull the rug out from somebody who is trying to survive and trying to support a family? So as Mr. Hager explained, we have an over-incarceration problem because we have an aggressive arrest and prosecution problem, misguided drug laws, and a history of discrimination and racism. So Blacks and people of color are more likely to be subject to criminal justice involvement and have something on their records. Now that disparity is certainly a nationwide problem, but it's at its worst in New Jersey. And so in terms of employment, there are protections for individuals who have criminal records in the employment process. And in large part, we look towards the Opportunity to Compete Act, which is essentially a ban the box law, which delays the employer's consideration in terms of the process until after the initial application process takes place and before a final offer is made. So the idea behind the ban the box was to allow individuals who have criminal records to get a foot in the door, and the employer gets to know the individual and make an investment, and they'll be less likely to discriminate against that individual. But the reality is that employers can still use that information to the detriment of those folks who have records, which we have seen and observed are largely folks of color. And so they still have instances routinely where they get rejections after they've done the training with HR and after they've got that employee ID. They can still be discriminated against, which interestingly enough, under the law against discrimination, there are protections there, right? Similar to the federal civil rights law. So having a criminal record is not a protected class, but to the extent that you can argue that there is a nexus between having that criminal record and being in a protected category, you may be entitled to some protection. And that is where we start talking about disparate impact. And that this also brings into play why, how discrimination looks now, as opposed to how it looked in the 60s. There's something going on here. And what we're focused on at the end of the day is the end result of moving through these systems. So if you have the prison system, the education system, the housing market, but for example, the prisons are filled with Black and brown people. And so in New Jersey, where the Black population is around 14%, and Blacks comprise 62% or better. So almost 2/3 of the prison population is Black. So what does that tell us about the system? It's hugely disproportionate impact on Blacks and people of color. And so staying with that criminal system, if we step back, we not only see the disproportionality exists in prison, but in terms of the over-aggressive policing in certain communities, and in turn, the decisions to make an arrest, to prosecute and sentence. Like Mr. Hager said, the decision not to provide a station house adjustment, a curbside warning. So Blacks and people of color are arrested and convicted at rates disproportionately higher than non-people of color. And this is something that flows through not only with employment, but it goes to housing, it goes to education, that the usage of that criminal record. Given the disproportion of the criminal justice system on Black people in New Jersey, using an arrest or conviction to base a decision or deny an opportunity to someone without any consideration of that job fitness, it discriminates against Black people and people of color, and that's disparate impact. So in 2005, the Supreme Court upheld the use of disparate impact claims under the law against discrimination. The case is Garrity versus Hilton Casino. Now, although that case revolved around the question as whether an employee leave policy was discriminatory against women, it can be applied to claims of racial discrimination as well. And so disparate impact theory is not only useful in the employment context, but it's also useful across substantive areas, including housing. The problem there, though, is that it requires a complicated legal fight to prove your claim in court. And it's also very expensive. You have to have an expert to bring these types of claims. So it's not every day that you can bring that type of claim. And it's not every day that someone could be entitled to relief. Which leads me to how we can strengthen the law against discrimination to provide protections for people who are facing these issues. One of the things LAD could benefit, adding specific protections around criminal records explicitly in the language of the LAD statute, and making it unlawful to discriminate against someone on the basis of a criminal record unless there's an individualized analysis based on the nature and severity of the offense, the time passed, the relationship to the opportunity. And then the requirement that a process must be followed. Employers or others, they have to issue a written decision. There's a notice and opportunity to provide what we refer to as evidence of rehabilitation and a clear path to appeal. Exploring limited look back provisions, which means you can only consider recent convictions. You can't go back further back than a certain number of years. There in the legislatures now, there's a bill, the Fair Chance in Housing Act, which currently is in a state where it's going through the legislature, but the more powerful one is on the Senate side, S-250, I believe. It's going to create a ban the box for renters, making it unlawful to ask about a criminal record until a conditional offer of housing is made, but it also limits the type of convictions that can be considered and creates that limited look back period we've talking about. It also embeds process improvement. It requires an individualized assessment, written denial and reasons, and also would have involved the DCR, getting involved in preparing model notices and making sure landlords are compliant with the data. But also regulations and guidance on disparate impact could be very helpful here as well, because not only are the folks going through the legal process trying to bring claims, but we need to educate employers. We need to educate folks that to the extent that they are using records against someone and denying them an opportunity, let's call it's discrimination. And so we need to make it, we need to educate decision makers and all people, frankly, and then just make it against the law.
No, pardon me. We have another question popping up for the CLEs. Akil, thank you very much for your thoughtful comments. I did notice when I was preparing for today's discussion, there was a 2016 guidance issued by the Office of General Counsel of Housing and Urban Development that kind of addressed the issues that exactly what you've been talking about. That is to say that criminal history is not a protected class currently under the Fair Housing Act, just as it isn't explicitly under the LAD, but that doesn't mean that you're foreclosed from bringing a cause of action, because as you and Ryan Haygood and others have pointed out, if the overwhelming majority of people with a prison or criminal history are Black and brown, and that is used as a basis to deny employment or housing, obviously it's going to have a disparate impact on Black and brown, particularly discriminatory if there's no rational relationship between this, exclusionary criteria that's imposed on people and, either the housing or, the qualifications of a job. The time has gone very quickly. And I wish that we had more time for some robust discussion. I just want to make sure that we get to the questions. And I know that there was a question about unemployment benefits. The question was, I provide legal services to New Jersey tenants of low income. Can we do anything to stop landlords from refusing to rent to tenants whose sole source of income is unemployment benefits? I am not aware that unemployment benefits are considered source of lawful income under the LAD amendment that I read you. I know that applies to Section 8. I'm not sure that it can be counted or excluded. Does anybody else want to opine on the question? I don't think that there's a clear answer. The next question is whether the PowerPoint, I guess that's Mr. Haygood's incredibly powerful PowerPoint. Where is that available, Ryan?
Sure. So I shared it with Whitney, and if she can get it to the attendees, I'm happy to do that. Or if there's or Rosemary, Whitney can email it to you and you could share it. I'm happy.
Okay, great. We'll see if we can get that distributed to people. There was another question that I think folks have tried to cover in their comments. I just want to give everyone an opportunity to say, if they hadn't had a chance to say, what protected categories and classes do you recommend be added to the LAD that have not already been discussed? I know that I have a bunch. I have domestic workers. I have persons with criminal records. I know Jean talked about having prisons and jails as places of public accommodations. Was there anything that we missed?
Immigration status.
Immigration status, yep. Anything else? Mr. Haygood, I wondered if you had anything that you wanted to say about when we talk about the history of the LAD, the objectives of the LAD, and the PowerPoint, the very powerful PowerPoint point that you presented. We talk about systemic racism.
Yeah.
We have some tools to combat systemic racism. When I look at the statistics that you shared with us, what else can we do? How else can we use the tools? What are we missing, if you will? And I hear Akil talking about one of the things that we're missing is disparate impact litigation, disparate impact regulations and litigation. And I open the floor up. Is there anything else that others can think of? One of the things that I'll say is it's not, the Division on Civil Rights has recently expanded. And so now we have a community relations unit, and we've also added an education and training unit. And I think that all of these parts work together. And I do really appreciate Mr. Haygood's comments that a discrimination doesn't just damage an individual, it damages all of us. And I am struck, as well as you, by the language in the statute and the language that gives DCR its statutory authority. We don't just work for righting an individual wrong. We recognize that this is damaging to us as a society, and DCR works in the public interest to remedy, rectify, eradicate discrimination.
Yeah. I mean, I appreciate that question, Rosemary, because it raises a point that Jean made earlier I was thinking about the LAD in like a policy context. So the LAD, the legislature intends that damages should be available to persons protected and should be liberally construed. So like recognizes a harm and then the remedy. In the policy context, there's often not a remedy beyond stopping the harm. Like if there's not an affirmative thing given. So to Akil's point, you stop the harm, but then like in terms of what the investment is, it's harder to get to that. So to your question, I was thinking about what that would look like in the policy context, because so much of the conversation is around how do you stop harm? How do you protect? How do you create a law that would provide a protection from the harm, but it assumes the harm exists, but it doesn't remedy the harm beyond stopping it, if that makes sense.
Right. Yep. And that is one of the profound issues that we all face in our day-to-day work, right? How do we stop? We can acknowledge that this event has happened and that it violates the law, and we can try and resolve it, but how do we stop it from happening again?
Right.
And so, I mean, I think, one of the ways is to make it clear that the conduct is a violation of the law and there are implications to that. Sometimes it's education. And I wonder, I'm going to just keep talking. We're going to wind up going over. But sometimes it's racism, systemic racism, ingrained prejudice. Sometimes it's a lack of education and information. And that may be more sometimes, Mary, in your field, in the area of disability rights. What is an employer required to do to accommodate somebody? What steps do they have to take? What constitutes a reasonable accommodation under the law? That sort of thing. And it kind of depends where you are on the spectrum and finding that balance and finding the resources to get there. I don't know if there were any other questions. I'm sorry. Yes, Jean, please.
Mary, I saw you were unmuted. I don't know if you want to go first.
Well, I was just going to respond, but she kind of basically said that, the thing about disabilities are unlike things like race, where you've got, the color of your skin, there's lots of people with disability is one where your disability is only unique to you. Everybody's disability affects them differently. And you may have two people with the same type of disability, but their functions are completely different. So you have to work individually. And that's the one thing with respect to disability discrimination, is it really is individualized, which is why the whole concept of reasonable accommodations means you have to have an interactive process, because the employer may have said, oh, well, we've had somebody with this disability before, and this is all the stuff we've done for them, but that may not be the right services for that individual, because that individual may be totally affected in a different way. So right. There is a lot of discussion. And the thing about disability discrimination is it really is individualized. Yeah. And one of the other things that I mentioned, but I don't want to get too much into it, but a lot of times what we see is a company may be doing everything right. They have a person that's worked there for 5 to 10 years and they've accommodated them and done everything right. That person gets promoted and they bring in a new manager. And suddenly that person who's had the accommodations, the new manager doesn't understand them, doesn't know what to do with them, and they stop giving the accommodations. And right. All of a sudden, what was working no longer does. So right. We've seen tons of issues like that when there's like a new manager or somebody coming in that's new. And that is it's very disheartening for the person with a disability, because they've done right. the job, they've done a good job. Right. And suddenly now they're no longer doing a good job. They're getting written up all the time, they're being harassed, and they don't understand why suddenly things have changed. So, right.
We have, I think, a minute left. Jean, did you have, yeah, please?
I just wanted to say, in the context of disability, we see that intersecting a lot with race, especially in the criminal justice system. And when you look at our prisons, they are also disproportionately filled with people with disabilities. And I mean, I'm thinking about a transcript I recently read about a parole in the context of a parole hearing. And what I saw jumping off the paper is disability discrimination, like people not understanding that the person in front of them was, confronting different kinds of disability issues and kind of putting this external expectation on them. So I just wanted to flag that it really does, in the context of the criminal justice system, kind of compound the discrimination going on.
Right. On behalf of Division on Civil Rights, I thank you all from the bottom of my heart for your insight, for your work, for your suggestions. And there's an open invitation to keep those suggestions coming. I invite everyone who's joining us today to join us next week in the continuing series when we talk about racism in public health, in the health system, and to check out the Youth Bias Task Force report that has been dropped in the chat, and the report that the DCR issued after we had our sexual harassment hearings last year. We issued a pretty comprehensive and wonderful report on what changes could be made to the LAD. Thank you all so much. Take care of yourselves. Be well. Thank you, everyone.